Good evening, everyone. My name is Ed Kazanovich. I'm town manager. We are here tonight for a scheduled open meeting law training session to be conducted by Town Council Attorney Hennigan. Let me first state a few things. So we have a sign-in sheet, so anyone who may come in, if you could ask them to sign in, because we are going to track those individuals who attend these training sessions with the town clerk. Also, this meeting is being recorded, so if there are board and committee members and employees who do not have the opportunity to attend tonight, they can watch it on YouTube or on our website and register with the clerk as well. So we have a number of employee handbooks. I know one is issued to each individual when they're sworn in by the town clerk. If you don't have one, you're welcome to take one. We do have a limited number. I'm sure we have enough for those in attendance tonight. So please help yourself. And what else do I have here? So I just want to highlight a couple of the common complaints that we see from the management side as a result of some open meeting law complaints that we received. I think first and foremost, it's, I think some of the complaints have to do with the requirements of the posting. Under the law, we're required to post a meeting 48 hours in advance of the meeting, excluding weekends, Sundays, and holidays. So please be sure that you abide by those posting requirements. Also, we received a number of complaints as it relates to the agenda items. Please be clear, and I'm sure Bob's going to touch on this during his comments. Please be clear that the agenda item is specific and it is designed and explanatory in such a way that it's going to notify the general public of the intent of the agenda. And that includes if there's an intended vote as well. Sometimes if the item does not indicate that a vote may be taken, then a complaint could be filed on that item alone. And we've had a number of complaints as it relates to our hybrid meetings. And it's very frustrating and very difficult. Make sure if you're holding a hybrid meeting that those who are attending remotely are able to hear as well as participate. We ran into a problem the other night. We had a 30-minute delay because our participants, who were many, weren't able to hear the meeting. So just make sure that they're able to do that. In some cases, we had to repost the meeting, even though votes took place. There were public hearings. We had to have those public hearings all over again as a result of a complaint. So with that, I'm going to introduce Attorney Hennigan, who has a presentation for you tonight. And we ask that if you have any questions at any point during the meeting, there is a period for a Q&A. Maybe we should just wait till then. If you could go up to the podium so the general public who may be watching this can hear, as well as those individuals that may be viewing this meeting at a later date. So with that, I'm going to turn it over to Attorney Hennigan.
Thank you, Eddie. I appreciate it. Welcome, everybody. My name, again, as Eddie said, is Attorney Bob Hennigan. I have an office in Worcester, but I've had the pleasure of serving as town council in Auburn for many years, more years than I like to think about now, but I've had the pleasure of being here, working with people in the town for many years. And during that period of time, I've had an occasion to come in and perform this type of a training session or participate in this kind of a training session with people to talk about particular items of the law and answer your questions if you have any and if I can. So that's what we'd like to do tonight, is go over a few of the items you can see from the agenda. That I'd like to start off by talking about the open meeting law, move on maybe to some quick questions. That's going to take the majority of the time, I would think. Maybe move on to the conflict of interest statute and take a quick look at that. There's always questions that sometimes come into play about Robert's Rules of Order and we can certainly touch upon that to the extent that it's relevant. The sources of the documents that I'm going to be looking with and for you is this handbook. This handbook is, as I understand it, is given to everybody when they become a member of a board or commission. And as Eddie said, there's copies if you don't have it with you. But I am going to point out various parts of this to make it easier for you to follow along with what we're taking a look at. And then the other document is the open meeting law guide put out by the Attorney General's office, which everybody is welcome to get online and read. You have a copy of a previous edition. There's not much changes, but you have a copy of a previous edition in your handbook. But I'm going to actually have a handout for the area that is to supplement the area that has been changed because of COVID in the law. So with that, let me just start with telling you about the open meeting law. The open meeting law in your handbook begins on page 7, and it flows from that section right along for several pages. But we're going to walk just through it. I'll just try to point out to you the various areas and highlights of the law and how it applies. Obviously, the purpose of any open meeting law is to ensure that there is transparency in the deliberation of your board or commission that you're on, particularly when it involves public policy. So if you're a member of a board or a commission, you have the obligation to assure that there is transparency in what you do, in what you talk about, in how you vote, how decisions are made. All of that is part of your obligation as a member of a board or commission in a municipality. And the page 7 section that I just referred you to is going to emphasize that the democratic process depends on a public having knowledge about the considerations underlying a government action. The only way a citizen can understand whether a person did or didn't do as a member is to listen to them speak about a particular item if they have an interest. Now, a lot of people won't have an interest and may never ask you a question about it, but you have the obligation to make that kind of a deliberation in open public meeting. So depending on whatever board and commission you are, what's covered under the open meeting law, it's pretty clear that all meetings of a public body are open to the public. And those meetings are usually meetings that involve deliberation and discussion about a public body's area of jurisdiction. If you're talking about something outside of your area of jurisdiction, it would not be constituting an open meeting or a meeting of that particular body. But here's the kind of an interesting thing is the open meeting law applies to any kind of a multi-member board, commission, council, authority, committee, or subcommittee. Maybe in your particular instance, you wouldn't have occasion, depending on the size of your board or commission, you wouldn't have occasion to have a subcommittee. But just keep that in mind, that subcommittees of a particular board can certainly fall within the jurisdiction of the open meeting law, and as long as that committee has been established to serve a public purpose. Also, what people I think have to understand is, what do we mean by deliberation? A deliberation is defined in the statute and in the pages that you have there as an oral or written communication through any medium, including electronic mail, between or among a quorum of a public body or any public business within its jurisdiction. This is where you can get into some trouble if you're a member of a board or a commission in terms of oral or written communications through any medium. So when you think about the various levels of mediums, electronic mediums that people have available to them today, you can see that the opportunity for communication between board members exists. So that includes obviously emails, and it also includes texts. So we have to be careful about what we do and how we operate in terms of talking with each other on texts and emails. I always use an example of a case that the Attorney General decided this is probably 2021 now, and it had to do with a text message and an email between two members of a particular board. In this case, it was in Barnstable Town Council, and it was an advisory committee that was established to review zoning and permitting issues. And one of the members simply texted to another member upon a question, yes, we should pass our ordinance and then move on to what we can do in regards to zoning and assist recovery. Whatever the question was a very basic question to this particular member by the chairperson saying, what do you think about this? And as soon as this particular person responded, we should pass this and move on to another stage, that was considered to be a deliberation because the people were expressing to each other what their position was on a particular matter. So the Attorney General's office, of course, found that to be improper and came out and made a finding. In this particular instance, they didn't issue any particular penalties, but there are civil penalties that can be incurred, oftentimes probably not. You have to be really egregious, and this probably wasn't. But I just use that as an example of how when you read this entire case and the exchange that took place between these two people, it really was kind of an innocuous exchange of ideas, but it was a deliberation, and so it was improper. So I just point that out to, suggest to you that you be very careful about how you operate in terms of exchanging ideas between members of your particular commission. Of course, distributing agendas or talking about scheduling or any procedural information, that would not be covered so long as the material that you're expressing does not express an opinion of any particular member of that particular board. When we get into emails, even if the email doesn't ask for a response, you can get into a situation where there's a deliberation. And again, a particular case that comes to mind is when there was a one-way communication from one public board member to another public board member that simply said, let me see if I had my note of what it was. It was a one-way thing where he expressed again this particular member of the board expressed his agreement with another members of the board's public comment that member had made, and he expressed that to him in a communication by saying, I agreed with what you said at such and such a date. And even that item was within their jurisdiction. That item was going to be discussed at a particular board meeting. Even that one-way communication, in this instance, of course, there's various facts to it, but on this instance, becomes an issue that the member of a board or commission has to be a little bit careful about. So I just warn you that one-way communications from one public body member to a quorum or business with other board members is an issue that one should really be careful about doing because it can open the door to some criticism and to some violations. The requirements for filing and posting, Eddie talked about this very briefly when he opened. Obviously, a public body must provide the public with notice of its meeting 48 hours in advance, excluding Saturdays, Sundays, and legal holidays. What information must be kept and put into a notice when you're publishing a particular notice? Meeting notices are posted, must be legible, easily understandable, have to have the date, the time, and the place, and have to include the items that the chair of that particular commission or board reasonably anticipates will be discussed at the meeting. And that, of course, reasonably anticipates is broad enough to have a variety of interpretations. And if it can't be proven that the chair could have reasonably anticipated it by some communication, there can be problems about that item being discussed on a particular agenda item. So I just want to make that clear to you that and again, there's cases, we found a case where that particular item a particular item was not determined to be reasonably anticipated. The particular vote in this particular case constituted some serious money, and they ended up with a $1,000 fine because they felt that was per person intentional. The Attorney General's office in that particular case found that it was intentional. So again, if you're a chair of the commission, or even if you're suggesting to the chair of the commission a particular, or board, a particular item, then I think you have to understand that the chair's obligation is to put on the agenda things that he reasonably anticipates should be discussed. And in addition, he has to reasonably anticipate them 48 hours before you discuss them, which is, sometimes the challenge for people to do. But that's what the law requires. And if there's emergency situations, you certainly can take those items up if they have to, if it could not be reasonably anticipated. But you try to make sure that if it's not an emergency, if a new item comes up that hasn't been properly noticed, properly put on an agenda, properly given notice to the public under this whole theory that we talked about in the beginning, the transparency of public bodies and transparency of public meetings. If that doesn't fit into that whole thing, it's be best to, if you can, hold that item until the next time that you do meet. The sections in the book that you have there talk about executive sessions and what process has to happen for executive sessions. I'm not aware of any other public body other than usually a board of selectmen or other commissions or boards that might be involved in some litigation that would have the need to go into executive session. There are 10 reasons that one board can go into executive session if they wanted. I don't think any of those without litigation being involved would probably fall within a particular board other than the Board of Selectmen, but I could be wrong about that. But my comment on this is because it's a detailed explanation of what is an executive session. I don't know if it's necessary to do that right here, is that if you would, I think, be advised before that issue came up, either from Ed's office or through some communication with my office, that you had a need for an executive session, and that we would advise you as to the steps that you would have to take to go into that particular executive session. But I'm not necessarily sure that I want to spend a lot of time on that, but it is in the handbook that you have, pages 11 and 12. There is a section, if you turn to page 12, there is a section that talks about remote participation. And I'm going to ask you if I could, just take one, Dory, when you and get yourself one too. I'm going to hand you a handout which is going to be a supplement to these pages. And we'll talk a little bit about remote participation and what it means and how you can go about doing that. And we'll talk about some of the problems that can come up because of that. So on page 12 of the handbook, there's a section you'll see that says remote participation. The law has passed with the law that you're getting in the handout is known as Section 20 of Chapter 20 of the Acts of 2021, and it temporarily alters several aspects of the remote participation rules. The rules we're going to talk about here are going to be in effect until March 31st of 2025. These rules all came into play during COVID, and they've been altered and changed a little bit since then, but these rules are going to be in place until March 31 of 2025, unless the legislature was to extend them for some particular reason. So I've given you a copy of the law, and we've kind of highlighted in yellow some of the sections that I think you might be wanting to be aware of. But I wanted to ask you to turn to page 2. Did I say page 2? Turn to page 2. And these are kind of the summary of what I'd like you to think about. Down towards the last paragraph, it says, these temporary provisions in Section 20 pertain to the open meeting law, contain two primary provisions. The first, public bodies may continue providing live, adequate, alternative means of public access to the deliberations of a public body instead of holding meetings in a public place that is open and physically accessible to the public. Adequate alternative means may include, without limitation, providing public access through telephone, internet, or satellite-enabled audio or video conferencing or any other technology that enables the public, and here's the key words, to clearly follow the proceedings of the public body in real time. That can become a problem, particularly when you have, as Eddie was alluding to earlier, some difficulty in terms of the technology. If you have a remote participation meeting, there is no substitution. You need to assure that the public can hear clearly the entire process of that particular meeting. There can't be any gaps in that you just skip over. There can't be anything you say you can correct later. It has to all be open. And if it means pausing the meeting until that is corrected so that everybody can do it, that's what has to happen. If that requires you to come back to a subsequent meeting afterwards, that's what has to happen. There can't be a substitute for any kind of a half-nil type of presentation of a meeting where people do not hear it. Now, there might not be anybody known to you that's present. I understand that can present some problems, but even in that instance, we would always advise, unless the issue before you is of such urgency, and that raises all sorts of other issues, the safer course of action, obviously, is to wait, close the meeting, stop the meeting. You can make a declaration of the reasons why very easily, and then when the whatever technical problem it is corrected, either reopen the meeting or have another meeting on a different date. So that is this whole thing. And there is a whole series of cases that have come down about committee members in a live stream of a broadcast, being disrupted. And this is the two members of a particular meeting couldn't hear each other. And by continuing that meeting, that was even a violation because in this particular instance, the committee continued on with the meeting despite learning that technical problems prevented the meeting from being streamed or broadcast live, and that the committee proceeded with the meeting. The commission went on to say at this point in time, in holding this as a violation, the person chairing the meeting may decide how to address the technical difficulties, but it is encouraged whenever possible to suspend discussion while reasonable efforts are made to correct any problems. Where they say here, where the Attorney General says it is encouraged, they do a lot more than encourage. They require it. And they may say, this is what you should do, but when you don't do it, they say this is what you should have done. So that is something that I just want to point out and make sure people are aware that it is a serious issue. And the challenge is with the technology is for all members of the committee to make sure that the public is participating in that. I've also included some of the other updated items that you would read on pages 12 to 13 in this particular thing, and I think they'll this particular handout, and they will just really explain the necessity of at all times making sure that what you're doing is transparent to anybody who's listening or watching. So I'll leave that. And again, that would be a substitution of the update of the law for pages 12 and 13 of your handout. Obviously, when you're chairing a meeting, the law requires the public to participate. Obviously, there has to be a chair involved in this particular participation effort. There has to be some control over a particular meeting. There has to be somebody in charge of the particular meeting, which is usually the chair. And so, although the public is permitted to attend, it's the chair of a particular commission or board that controls that meeting. So that chair, the public doesn't control the meeting. The chair has to recognize who wants to speak. The person can only be recognized when the chair allows that person to speak. And at some point in time, if meetings were so disruptive, the chair would have a right to just suspend the meeting, have that person removed from the meeting. That's how strong a chair can be if they have to in a particular instance. Oftentimes at public meetings, people who attend want to make recordings of it, which is allowed. It's just that the chair would have to disclose to everybody there that a particular individual was recording the meeting for that particular purpose. As part of your deliberations of your particular meeting, the body that you're working with or for is required to keep certain records of what you did. And so the public body is required to create and maintain accurate minutes of all meetings, including executive sessions, but we've touched upon the executive session part. The minutes, which must be created and approved in a timely manner, must state the date and time and place of the meeting, a list of the members present or absent, and the decisions made and actions taken, including a record of all votes. And then they'll talk about it. And again, this is, let me see if I give you a page for your reference. Probably page 14, 13 to 14. There's a requirement that the minutes summarize the discussions that took place. And I've seen in some instances where people try to literally write down what John says and what Mary says and what Peter says and try to give a transcript. I think the regulations and the law is pretty clear that you don't need to have a transcript. A summary of the discussion is what's needed. If you can provide who's ever taking notes of a particular commission board meeting, if you can take notes that summarize that discussion, that would suffice. If you're really good at writing and you want to put down word for word what people are talking about, I'm sure that's fine, but it's not required. But what is required is that there be a record of the vote that's taken. Obviously, you can't take a vote by secret ballot, so I've never seen that done, but they mention that you can't do it. And at the end of a meeting, if you've had a lot of documents that you wanted to discuss or were used at that particular meeting on a particular item, those should be reflected in the minutes and also should be included in the minutes for the record of that particular meeting. Although you wouldn't likely be involved in responding to any public records requests, people have a right to request those minutes, as you know. They have a right to review what people decided at that particular meeting. Those minutes are very, very important to the overall operation of government in any particular town. They're very important to assure the transparency of a particular board's actions. So there is an emphasis that people would ask that they be written and approved in a timely fashion. There is a discussion about how long that can be. It all depends on, obviously, the workload of the people involved in the commission or the board. If you get into several months where you haven't approved previous minutes, that can be problematic. Several months being 2. So 2 months is starting to stretch it. 1 month is probably a good time, depending on how often you meet. Keeping in mind that if someone is recording minutes of the meeting as it was being done, but hasn't been written up in terms of a final presentation for voting to accept, those notes and those minutes are discoverable and also obtainable by public records requests. So the fact that it's a minute isn't necessarily, is delayed, doesn't necessarily mean someone might not get those particular documents. In an executive session, minutes are treated entirely different. An executive session, minutes or notes are not, you're not required to give them up, so to speak, to anybody who asks for them, because those are still, you're in an executive session for a particular reason, and until that reason ends, you would have the right to keep those minutes in a manner that wouldn't require you to disclose them. And then I just would just point out, and I think you have them in here, it's on page 17, you have what are called the Code of Massachusetts Regulations. If you're not able to sleep some night, they're very exciting, and you could read them. I think they start, so I can find my page here, yeah, page 28. But they do have some, the nitty-gritty of how public meetings are run, and the nitty-gritty of what's required for posting, the nitty-gritty for requirements of meetings. There is an entire section in there, section 29.10, which deals with remote participation. I would just ask you to make a note in your own record and in your own booklet that those do not apply right now, that the document that I handed out to you about section 20 of chapter 20 of the Acts of 2021, that is the controlling document right now until March 31st of 2025. So, Eddie, those are my questions. Those are my comments on the open meeting law in relation to how it fits into the handbook. I don't know if you want to take questions now on the open meeting law, if there are any, or do you want me to just continue on? What do you think is?
Maybe we should open it up for questions now, and I would suggest if anyone has a specific or any question, if they could go to the podium, so we have an opportunity to record it as well as make it available for any of the viewing public.
He didn't say it, but he meant easy questions, is what he meant.
Thank you for being here. Steve Chambers, I'm on the select board. In the first example you mentioned about Barnstable, a text between two people. Can you clarify that the two people was a quorum, and that's, okay.
Yeah.
So on a 5-person board, a text between two people is still allowed?
A text between two people would be, yes, because those two people are deliberating. So it's not ultimately coming to a resolution, but those two people are deliberating over a particular item.
So anyone that's on a board can't deliberate anything, even one-on-one, when there's no quorum?
When you mean, are they at a public session or are you doing a
Oh,
private?
between text, or if
Yeah.
they're discussing something?
You'd have to give me a little bit more of an example. Let me see, if you want, I can tell you what the example was here. Let me see if I can find it. The issue becomes is, are you providing information to that particular person of where your position is on a particular item, and what that person, how that person's going to vote on a particular item? If that's between two people on a particular board, then the public has a right to hear what that person who's texting what his position is. The public has a right to hear in what that person is thinking in terms of the transparency of the issue. Does that answer? See, the reason.
So I just, again,
question, yeah.
when things come up and we're discussing, like, whether it's an agenda item or something, like, and I'm not saying deliberating on things, but sometimes that comes up, and I was always under the impression that if there isn't a quorum, you are allowed to have discussions. And what I think I just heard from you was, I'm not allowed to deliberate with anyone I serve on a board with.
Correct. Now, if you're talking about agenda items and scheduling items and other issues that are not, talking about a particular topic within a jurisdictional issue of a particular board, you certainly can talk about that. But in this particular case, this was between two members, and I'll find out if it was 3 or 2. I think it was 3-member board. So in your instance, that would probably be a quorum. That might be what you're getting at. Yeah, the issue to me in this decision was that a text exchange that said we should pass our ordinance and then move on constituted a deliberation outside of a noticed meeting. And so if that occurs between two people of a 3-member board, we would agree that that would be a deliberation. If that texting agrees with a 5-member board, I would be very, very careful about doing that between members of a 5-member board, yes.
Thank you. And then as far as remote participation, you mentioned it can be phone call, it could be remote meeting. If you post in there that there are multiple ways and one of those technology features fails, can you pause the meeting or can you have it stipulated in the agenda? Should one of these items drop out, please try these other, so we can either keep the meeting going. And I know several boards in town have already rescinded going that way because they just don't want to deal with the hassle, but it does limit participation. So if you really want to be open and honest, I feel like allowing that in some manner, but having the protections of if technology does fail us, please call in. Please understand we are in an in-person meeting and that technology doesn't supersede it. And if you can continue on and say, there's parameters like, hey, should technology fail, we will delay that for a half hour so someone could physically come here and have that discussion.
Yeah, I'm aware that that is done. I've looked to see if there's guidance. I haven't found the guidance that one might expect to be existing because they haven't made a decision or I just haven't found it. But here's my caution on that, is that if you look at the overall principle of transparency, under the guise you just talked about, if you advertise A, B, C, and D are the electronic forms of your participation in this particular meeting, and one of those forms fails, to me, you're limiting the transparency of that particular meeting. And so you either should not have it all on all these mediums or limit the mediums that you're going to be involved in and assure that those are working. But I don't, without knowing a particular set of facts that could be implied, I don't like the idea of a meeting proceeding when one of those particular mediums fails, because I think you run into problems in terms of the transparency of that particular meeting to whatever group might be on that. I mean, I've seen it where people would say that they did a roll call to see who might have been on a particular meeting, and no one answered, and whether that was sufficient evidence to say nobody was there. It still caused problems.
So if you post that it is not online or accessible by phone, but still wanted to present it out that way, is that allowed?
I'm sorry, if we did what?
So let's just say like the online meeting
Yeah.
aspect is, it's there and you can join, but if it's defined as this is a physical location meeting and it's only here for those, viewing pleasure.
I think once you define it and once you put it on through a different medium, you've got to carry that through. Your safest bet is to carry it through and not try to say, well, you could come to the meeting also, because you're offering it as a particular medium out there.
So every remote meeting that we have is a liability.
Well, they all are, yeah. I mean, they're a liability because if they don't work, then you have people who you are theoretically anyways disallowing from that participation in that particular meeting. And that's the issue that always drives me in terms of looking at things is, have we done something that prevents the public from participating in this particular aspect of this meeting? And that's how I would always look at it. So if it does fail, if something does fail, even though they've been told, you can come down to the meeting and so forth, even though there's all these other varieties, that bothers me. And there's always exceptions to it depending on what the facts are or depending how it works out or whatever evidence could be developed that shows in this particular instance there was nobody here and there's nobody affected by it, so forth. All that could come into play. But from an overall perspective on it, I would suggest that if you're having a technical problem, you take the measured, safer step of making sure that's corrected and then continuing, or stopping what you're doing and getting it done again at a different meeting.
And then how long can someone go before they file a complaint? Like if a meeting
Oh, yeah.
happened today, can they go back 5 years or?
Oh, no, there's a time frame. I saw I know in here that it talks about the complaint time frame. There's a whole section. I can provide a summary of it, but I think they only have 20 or 30 days from the date of the complaint. I just don't remember whether I think it might be 30 days. They have from the date of the complaint to file, from the date of the violation, they have a certain period of time to file it, the violation. But it's not, they can't go back. They can and file a complaint, but it won't get anywhere.
Thank you.
Thank you. It is 30, is that what it was? Yeah, 30, thank you.
John Regan, Planning Board. My question is on remote meetings, we were told that we could vote it out and not have it. We can do that?
Yes.
Good, that's all I need to know.
Beth Chamberlain, Superintendent. Remote meetings seem to be the hot topic.
Certainly is.
So we've had a couple of situations. So we sometimes have kids at our meetings because they come and they present. And we had a situation where something very nasty showed up by someone participating remotely. What are the parameters that we can put on to restrict to some degree so that that doesn't happen because it was awful and it was upsetting to a lot of people? Are there things we can do? Is there any guidance on that?
I know there are. I've read about them. I don't have, I will get back to you with an answer on that. I don't have an idea, because and a couple of reasons. I got to do a little more, I'll do a little more research on it, but the research I'm going to get into is going to have a technical aspect to it. And that's where I leave the room when it gets into a technical aspect of how we go about doing it. So there are things that can be done to control it. I'm just not familiar enough with it right now to tell you what they are, but I can provide that.
So can I ask you, if we have members of the public at the meeting,
I'm sorry, if you have what?
members of the public
Yep.
coming into the meeting remotely, all of our members participate in person. But if we have members of the public, from the public who are participating, and there is a mechanism by which, when we have, public comment, that they can be recognized, is that sufficient to allow their participation in the meeting? They can hear the meeting, they can see the meeting, but the only way they can participate is if they formally raise their hand to do so.
Sure.
That's
Yeah,
acceptable.
Yeah, sure. I mean, that's order to the meeting, sure, for sure.
Okay.
Yeah.
All right. All right. Thank you.
I'll get back to you on that.
All right. Thank you.
Beth, we had an appalling situation similar to what you experienced. It caught us totally off guard. It was, how should I put it? It was rated R. We ended the meeting and then restarted the meeting. It's the only way we could get it off. And it was done in a manner that we reacted in panic because we didn't want the general public, we didn't know what the general public was seeing for those individuals who were participating remotely.
My worry are the kids at our meetings. Not that I want the adults to see either, but we often have first graders at a meeting.
So we couldn't clear it off the screen. Our only reaction was to end the meeting, and then we restarted the meeting. Now, whether that was proper or not, or there was a violation, we don't know, but I think we did what we thought was best at the time.
since we're on those examples, with respect to the recording that was made of both of those meetings, do we have to keep copies of the material that was edited out?
What do we usually do with meetings? They're kept, right?
Yeah, they're loaded on YouTube and they're stored here on the town server, on my server. But in the past, I've had to ask permission from you and town manager to edit material out of a meeting.
So you're talking really about editing material out versus not having that meeting?
Yeah, once the incident has happened, then to remove it from the meeting, from the copy of the meeting, do I have to
Yeah, no,
keep a copy of it?
you don't have to keep a copy of what you edited out?
Yeah.
Well, again, my suggestion would be that it be kept, but it's not a public record. It's just,
Yeah,
it's
yeah,
kept.
we've-
Just so in case anybody questions why on a particular meeting you have this blank section or blackened out section between point A and point B, we would be able to show, someone in the Attorney General's office or some judge somewhere what it was that was taken out. That would be important to have as a record, obviously, but that certainly can be removed from the public record of what's going on, yes.
Yeah.
And I haven't seen what Eddie's referring to, but,
Yeah, I edited it out seamlessly.
okay, yeah. You want to talk to
And Chris,
Beth?
if I may, I think there have been instances, although few, that I think you warned the public of maybe some abusive or foul language that may be contained in the YouTube video, correct? Correct. But did not edit it out? You were-
No, I edit everything out. If there's anything obscene in there, if there's anything not part of the meeting, I'll put like a beep in it, a long beep, but I'll maintain a record of it on the town server. So both incidents, we have copies of it, if anybody wants to see it.
Thank you, Mr. Hannigan. Dwarkesh Nalan from Planning Board. So going back to Steve's question, that's the aspect of the quorum in a 5-member board becomes interesting and important, especially as there is a tendency for board members to just understand some of the nuances in a topic. And so is there, when I read this, it says, if there is communication in a serial manner from one board member to another, that essentially feels like we are bypassing the requirement, that becomes part of, violation, right?
That becomes problematic from my
Problematic.
position, yeah.
But if
for
it's
sure.
just one board member talking to another board member in a 5-member, board, is that still an issue when there is no serial aspect to it?
Tell me what they're talking about.
Maybe just one of the discussion topics for that day.
What are they saying to each other?
Let's say, just say maybe one person is asking about the history of a particular, topic that must have come in 5 years ago.
And is that person who's asking about the history asking about that history to better inform that person of what's going on?
Yes.
And is that person who wants to be learned in terms of better history of what's going on, is that going to help that person decide where that person should vote back and forth one way or another?
It helps create a more holistic view on the topic.
And so would you agree with me that that person then could be deliberating over what that person wants to do on a particular night?
Yes, but it still doesn't meet the quorum requirement, right?
Then I still have a problem.
Okay, thank you.
Okay. I'm gonna tell you right now, I'm really, there might be other people who disagree, and I get that. And there are these fine lines here but I've always tried to be consistently very, very conservative in how would I advise a board or commission to operate. So recognize that I am being very conservative in my position on this.
John Regan, Planning Board again. based on Duarkesh's question, my question would be if two members talked, one member called another member, and didn't understand something on the planning board for the plans, is that other person allowed to explain it to him?
If I may, is there any reason why that member couldn't seek that history or that clarification through the town planner instead of another board member?
Sometimes when it gets into the engineering aspects and what it's supposed to do, the town planner wouldn't know that. But anybody who's got a construction background probably would.
And is it important, in your example, for that discussion to take place between those two people instead of it being taking place at a meeting? In other words,
Well, sometimes if that comes up in a meeting, it makes the planning board look like they don't know what the hell they're doing. Let's
see,
try to prevent.
I'm used to looking like I don't know what I'm doing, so it doesn't, you know.
I'm always used to that.
So it doesn't bother me. But look, it is a fine line what you're asking here, okay? One could make an argument that it's just
It's informational.
it's
not
information
deliberation.
and it's not deliberation. We do know it's talking about a matter within the jurisdiction of the planning board, correct? We do have two members of a board that are going to be talking about a matter within their jurisdiction. So just, and the third thing would be deliberation in terms of the definition that I gave earlier. So if I have two of the three elements that I caution against happening, and the other one being deliberation, I'm hard pressed to say that you're not deliberating.
Okay,
And I know it makes it difficult, but if you're texting or emailing, then there's a record of what you're doing.
I'm smarter than a text or email.
What's that?
I'm smarter than to text or email. That's permanent. A phone call isn't.
Well, text. I'll just confirm that a text and an email is permanent. Yes, I'll confirm that. Yeah. No, I understand.
All right, thank you.
Any other questions? No one listened to Eddie when he said easy questions, but those are great questions, though. I mean, this is a hot topic. They're very difficult. It's a very difficult issue, and it is obviously factually based. So every particular situation depends on the facts that are involved. So, but again, recognizing that I am very conservative on it, the less you can deliberate between members, the better off everybody is. It doesn't impact then the transparency. And you might be talking innocuously about things too, and I understand that. But.
Hey, this is Jeff from the Channel Committee. One more question on that topic. How did these texts come up? How were they discovered? Just curious if there was an issue or something.
Oh, well, if I were just to make a public record request for particular minutes of a particular meeting, you're going to ask also to include the texts of various members of the board. So you would have to produce them. It's public record.
Okay, gotcha. Thank you.
Yep. All right, I'm going to move on. Is that a clock? I can't even. We got time? You want to keep moving? I'll just touch upon, give me 5 minutes and I'll just touch upon the conflict of interest law, which is Chapter 268A of the general laws. And it is also in here that I didn't write down in my notes where it is, but it is, I think you have it marked, page 42. Obviously, what I'm about to tell is innate, you know this anyways, but I always bring it up to talk about Chapter 268A because of the fact that it involves civil and criminal penalties to the individual, not to the town. And so we want to make sure that you are aware of what your conduct can be. They've done a nice job, I think, in terms of requiring you now to take a course in conflict of interest and to sign a certification that you've taken it. And I think I have to take it every 2 years, I think it is. And it is interesting that they'll present a fact pattern that we all have to sit and think about for a few minutes, and it makes you think. So I encourage people to use the tools that are out there, and I think they're cited in the handbook. But obviously, I just wanted to point out that if you are in a situation where you think you have a conflict question come up, and you don't know how to proceed, then you can seek legal advice from either the State Ethics Commission, or you can through town council as to how you think a particular aspect in the law should be applied. But obviously, you can't ask for anything or anything of value in order to take a position relative to an applicant's application in a particular board or commission. You may not ask for or accept anything worth $50 or more from anyone with whom you have official dealings. This is regulated of gifts. This includes sports tickets, cost of drinks and meals, travel expense, conference fees, gifts of appreciation, entertainment expenses, free use of vacation homes, and complimentary tickets to charitable events. You may not hire, promote, supervise, or otherwise participate in the employment of your immediate family or spouse's immediate family, and you may not take any official action which will affect the financial interests of your immediate family or your spouse's immediate family. You may not take any official action affecting your own financial interest or the financial interest of a business partner or organization that you serve as an officer or director. Unless you qualify for an exemption, you can only have one job within the same municipality, and you may not have a financial interest in a contract with your public employer. And you cannot use your official position to obtain unwarranted privileges, which is usually the one that can create the most difficulty. There is the appearance of impropriety under Chapter 268A, that people unknowingly perhaps do some things that could give the appearance of an impropriety. And so we ask that obviously has to be taken into consideration, that you cannot use your official position to obtain unwarranted privileges for yourself or anyone else. I think the handbook that you have, I think it lays out by examples too, some very, very good examples here for you to look at in terms of the conflict of interest law. But I do encourage, if you think you're in a situation where you're not sure whether you should proceed on a particular matter, before you do that, I encourage you to get a hold of Eddie and his office, and they'll either refer you to the State Ethics Commission for their opinion, or you can you can ask us for an opinion. If we, as town council, if we write a formal opinion relative to a formal question, that has to be filed with the town clerk. The State Ethics Commission is a little more confidential. So just keep that in mind. The final thing, just very, very quickly, Robert's Rules, and this is also somewhere in here. I saw it. I think it's page 7, it looks like. Somebody asked a few years ago about operating and running a meeting, how it was done, what's required of votes and so forth. So we just put together this little chart, and it is on page 6, I guess it is, page 6. Obviously, you have a topic that comes up at a particular meeting. At some point in time, after some discussion of that particular topic, somebody is going to decide that they want to do something relative to that. That obviously is called a motion. Somebody would make a motion. The motion is only going to be acted on if it's seconded. Someone would second it. There is a requirement under the Roberts Rules that you then discuss the motion because it's been seconded. Now, it's usually the same discussion, that's already been had, but there is usually a chair or someone would say, is there any further discussion relative to the language of the motion that would change anybody's position. Usually the answer is obviously no. But there would be deliberation and debate, clarification of anything that would come on here, and then you would have a vote. Amending a motion, you would have an amendment which would be seconded. Discussion would take place on the amendment. If an amendment passes, original motion known as the original motion would be amended, and if the amendment was defeated, you would vote on the original motion. And then when, in terms of abstaining from voting, sometimes there's questions of abstaining from voting. When a motion is brought to a vote, members may abstain from voting. However, for the record, those members should explain the reason why they are abstaining. The most common reason for abstaining is that a potential conflict of interest exists. The inability of a member to reach a decision is not acceptable reason for abstaining. So if you have a conflict and a matter comes up for a vote, I've said this for every year I've been here to people who have asked that if you were on a board and you were in a situation where there's a conflict that you have because of the location of this particular matter, or this, you know the people, not know the people involved, but you have a financial interest with the people involved and so forth, that you make that clear on the record and that you physically remove yourself from the table or the meeting room until that particular matter is discussed and resolved. And you don't go into the back room and indicate by hand signals what your thoughts are on that particular matter. So, although that's been done. Not here, but that's been done. So that's really what I would advise if there's a conflict. You want to remove yourself from, again, this whole idea of appearance. Get out of the room, wait till that particular issue is over, and then come back to the room, and then nobody can question anything or any intent on your part, and you're done. Any questions on conflict or Robert's rules, or? Yes.
Like you said, you remove yourself from the board, but can that board member recuse himself from that portion of the meeting, sit in the audience because it affects him as a citizen? He's not going to vote, but can he have a comment as an Auburn citizen?
Putting my conservative hat on, I'm going to suggest to that board member that his role as a private citizen at that particular time puts him in a situation where an appearance of impropriety could be created, and that if he wants to avoid that appearance of impropriety, he declare himself in conflict and he remove himself from the room. That's what I would advise to that particular board member.
My next question is, if you're in a meeting and someone from another board comes in representing another board and starts asking questions that relates to their board, isn't that a conflict?
What would, yeah,
We had the occasion the other night. I had to tell the individual that that's for that board, that's not for this board. And then I find out she's a member of that board, and then she gets back up as a citizen and asks the same damn questions as a citizen.
mm-hmm.
How do we get around that? Because it was a waste of time.
I don't know. A person comes in as a citizen, starts talking about matters that don't pertain to the planning board but pertain to other boards.
Correct.
And that person is directed by the chair that says those issues aren't in front of this board. You need to go to board A to resolve them. Does that person then leave?
They can stay and
Yeah, whether they stay or not. I
Meeting,
suppose.
they came in and
I don't know if
identified.
when I talk about conflict, I'm talking about conflict of the 5 members on you're taking the planning board, the 5 members of those planning boards on that issue. Now, if she comes in and she's a member of a different board and wants to raise issues, I'm not sure I would classify that as a conflict, but certainly seems to be misplaced. But
Yeah, it wouldn't be protocol. They should,
yeah, there's
especially
some
when
of
they're
that
a
to it,
member of
but
that committee they're asking the questions about.
yeah, I see your point. I'm not sure I would necessarily classify, certainly, there's nobody on your board that has a conflict.
No.
You're saying, is it a conflict for this person? So if you're using the term conflict in terms of, is it inappropriate? Maybe that's the word. Maybe it's inappropriate. It would seem to me, maybe it would seem, but I wouldn't necessarily put that in the realm of conflict under Chapter 268A. That's what I would caution on.
So under the same light, if a board member accuses himself from the meeting and leaves the room, till that portion's done, then he's notified, he can come back, run the next subject. If they come in and identify themselves as a member of another board, ask the questions, I stop them, tell them it's from the other board, they go back and sit down, they get back up to the podium, say, I'm so-and-so, I'm a citizen.
Yeah,
What do you do then? It was the same damn questions.
I understand. You are the chair.
Yep.
And so as I said earlier, the chair controls that meeting, and I know it's not easy, but the chair controls that meeting. I don't see why a person would speak on behalf of a particular board and then speak as privately again as a citizen.
Oh, you had to be there.
But there's what you tolerate as chair is really
Not much.
it's really what the answer to your question is. I mean, the meeting has to be controlled. If you suggested to the person that it's probably inappropriate for that person to come back up and say the same things that he or she has already said, and the person continues to go on. I mean, I don't know how long it would go on, if it's a couple minutes, I don't know. But it would be an issue of control, I think, over the meeting versus saying that person has a statutory conflict of interest.
Okay, thank you.
Meg Roach. I'm on the Zoning Board of Appeals.
Oh, yeah.
Do you have an opinion, judging by what you've said tonight? I think I probably can guess what it's going to be, but on voting, in terms of being roll call or in terms of being all in favor, aye, any opposed, nay. I think pre-COVID, when the meetings started being remote, we went to a full roll call. But I just wanted you to chime in on, is that required? Can we do the all in favor if a motion is brought and seconded? Or do you advise that we do a roll call on every vote? And I mean like opening meetings, closing meetings, motions. What's your thoughts?
There's I'm not aware of a protocol, is there? In the town?
They're not doing remote meetings anymore, right, the ZBA?
We are no longer doing remote meetings in the ZBA. That is
I see,
out.
okay, I see what you mean.
Voted that out.
Okay,
And I think when we were remote, Bob, Chairman Tatro, he did them as roll call because we all weren't in the same room. So it was a lot easier for the record in the minutes and whoever was taking them to say, oh, Roach, yes, Chacolo, no. But we continued to do that, and I think there's a little question as to, is that required? Or can we, when we're all sitting up there, can we just do the yay or nay?
what do you think my answer is going to be?
Well, if you're going to take your conservative hat off and put it on, then I think you're going to say best practice.
Yeah, the best practice is to
Roll
have a
call.
roll call vote.
Okay,
Yeah, I mean, if it comes up 5 yes, then it's, the record only has to
Right, and it's
indicate it's
easier.
unanimous, but if it's 3-2, then,
and I think you'll probably agree, maybe like opening a meeting, things
Yeah.
like that can be a little less.
a little
of
less
the-
informative. I'm talking about the votes,
The actual votes, roll
because
call.
those are going to necessarily be subject to appeals.
Okay,
as you-
yeah, we're going around the horn on everything. It just seems like it's
I
wasting
understand.
a little.
Yeah.
So, okay, great. Thanks so much. Thanks for being here.
Thank you. Anything else? Eddie, that's what we got. I got nothing more. Unless we want to talk some more, or anybody has questions, I'm more than happy to pretend I know the answers. But, yeah. Thank you all very,
Thank you for your participation. Thank you for your questions. They were, I'm sure, helpful to a lot of you who may have been involved in a similar situation. But on behalf of town administration, on behalf of Attorney Hannigan, we'd like to thank you for your service. It is much appreciated, and if you have any questions, feel free to call the office. Thank you.
Are they done? No, well, you just closed the meeting, right? I just wanted to know about like revised meeting minutes. We have to post 48 hours. If there's a need for a revision, what's the threshold that it has to get? Like it doesn't count a revised agenda.
I'm sorry, are we talking about agenda or meeting minutes?
Agenda, sorry. So
Yeah.
the agenda comes out, let's say it was missing to take a vote or potential vote, and you wanted to address that. Can a revised agenda still be provided?
Yes. I think even in the language of the handbook, the Attorney General's office will suggest you could come, it's advised to come in with a revised agenda. If something came in on an emergency basis, you mean? Or even after, within the 48 hours, but after the first one was put up?
Yeah, I would always like it to be 48, but just sometimes things get missed or misconstrued.
So if it's after the 48, then you got a problem.
Okay, so kick it to
Kick
a
it to the
further
next-
meeting.
Unless it's an emergency.
Okay, thank you.
Thank you.
Sorry.
It was a great question.
Following up on Steve's question, it's a good question. If there's an agenda item that does not express an intent to vote, and it should have, but it doesn't change the intent of the content of the agenda item, but you want to add to that after the 48 hours, a revised agenda item that does reflect the vote, is that?
So you're clarifying?
Yeah.
You're not adding, you're not adding an item,
Not
you're
adding.
clarifying?
Yes.
Then I don't see it. In fact, we had that, where an item was moved from, I don't know, item number 3 to item number 7, and that was challenged.
Okay, so that's what I was just
Yeah,
trying.
I'm sorry, I didn't.
So I'm just looking for that threshold. If you're actually adding an additional kick it
Item.
to the next
Can't do
meeting,
it
if
to the
it's
next
not. If it's on there but just has slight edits, or maybe, again, adding potential vote because that was missed, or, so,
I think you're going to be okay.
Okay.
I think someone could still say, okay, I'm going to complain, but I mean, I think that Attorney General's office is not going to.
we're always going to complain. We're humans. That's what we do. But I just want to make sure we're.
Yeah, no,
and
I'm
again,
sorry, I
I think
misunderstood your question then, okay.
most of these boards do very well, and I'm saddened by the fact that remote meeting has been a headache, because I think it does encourage more people to be involved. And I'd like to, hopefully, we can find some legislation, or the Attorney General can come down with some guidance that still allows it, but doesn't hold us accountable.
I agree, let's hope.
Thank you.
And lastly, if you didn't sign the sign-in sheet, if you could, that would be much appreciated. Thank you for coming out. Enjoy the evening.
Thank you all.